I'm Randy Landrino, president of US Inventor. We're a nonprofit fighting to restore the rights of inventors in America. And what that really means is that if you're an inventor and you have a patent on something, you should have a legal ability to stop a large corporation from just taking it. And that's what we had for 200 years. You had what was considered a property right. And it wasn't easy to fight a large infringer, but it was doable. That has all changed. About 10 years ago, a law was passed called the America Invents Act, which created an administrative court called the Patent Trial and Appeal Board, the PTAB. And what this is an administrative court. There's no jury, there's no lifetime appointed judge, there's very little due process, and 84% of the time, the patent in question is invalidated. Now, these are only patents that are really valuable. These are patents where large corporations have decided they just want to take the technology without paying the inventor, and they do so, and then the inventor tries to stop them, and then they try to invalidate the patent, and 84% of the time, they succeeded in validating the patent. This is very un-American. This is the opposite of what enabled America to become the worldwide leader in innovation, which began at the very beginning of our country. Many people don't realize the American dream is totally tied up with the rights of inventors, because that's where America started. America was the first country to give inventors, to give anybody from any walk of life who comes up with something valuable and novel, the right of ownership to it. And that created this huge incentive that other countries didn't have. And that's what caused America to be so innovative and to be so successful in the world. And what really made us different than so many other countries, one of the key things, well, that has all changed as a result of this law that passed in 2011. And we are all here today for a court hearing where basically we're being heard for once. The system got broken because inventors weren't being listened to. And I will let these other inventors who are here today for this hearing tell you why they're here and why they think this is so important.
My name is Josh Malone, and I've invented a few different things. One that's I'm most common known for is my invention called bunch of balloons.
Unleash the thrill of summer with bunch of balloons.
It's been the number one selling outdoor toy for the past 5 years. We put it on Kickstarter first, and it just blew up and went viral. We had 21,000 backers, raised almost $1 million, and then on Kickstarter, this telemarketing company surreptitiously supported my campaign. I use the term loosely, and so I unknowingly sent them a first edition of my Bunch of Balloons product, which they proceeded to take apart. They changed the color, and then they went and shot a TV commercial. And they raced me to market. They ended up in market. This is a huge, major American company, and they realized, hey, we don't have to invest R&D. We don't have to do experiments. We don't have to have failed products. Let's just get rid of all that overhead and find the ones that work, and then just take them. And that's what all these big corporations are doing now, because they're not innovative. It was inherent to me that in America, if you come up with something no one's ever thought of before, and you follow the rules, you get a patent on it, that gives you the rights to it, and you own it. That was key. Like, I couldn't take these chances, spend many years without a paycheck, hundreds of thousands of dollars, put my family's future at risk, if there wasn't some security if I succeeded. And so the patent was integral to the motivation to even try to start a company.
When you're just some little guy with a big idea, and that big idea is a patent, the only asset you have is a patent. A patent represents an asset that can be collateralized, and investors can accept that as collateral, and if you've got a business, they can foreclose on that collateral, license it, and get their investment back. So if you can't enforce it later, you don't get investment.
What we have run into is there are multiple domestic and foreign commercial entities would like to basically copy and frankly, a lot of times just stealing what we have invented. And we are not getting sufficient protection from the current system, because it is very easy for any infringer to come about and challenge our patent by going through the IPR process with the PTAB.
The Patent Trial and Appeal Board is what the big technology companies are reverting to kill our patents. And when you sue somebody for infringing on your patent, they run to the PTAB and they file an IPR. And the IPR rates are 85% invalidation, which is crazy.
Back in the 80s and 90s, early 2000s, when we had a level playing field where small companies and large companies could collaborate and where people understood the value of the intellectual property system and respected it, you could form partnerships and joint ventures and collaborations, and 1 + 1 could equal way more than 2. Small innovators who had taken big risks could connect up with larger companies that had market share, and everybody could win. It was a win-win. Today, the playing field's completely imbalanced.
Years ago, an inventor would go to a federal court and have his day in court if someone did knock them off, and there was a fairer playing field. But since the AIA, which is the American Invents Act, the rules have changed, and basically you can lose your patent before even going to a federal court and having your day in court, because the patent office who issues you a patent can take it away through this what's called post-grant review and the PTAB.
PTAB is the Patent Trial and Appeal Board. This was something that was created by Congress, and if you really look at it, you can kind of see that it was really created by big tech, big companies, as a way to kind of destroy the patent system and destroy the small guy. And basically, that's one of the reasons why I'm here today, is because as an inventor in today's patent system, I just kind of have to sit on my hands.
Why is that?
Well, I guess I can't really do anything with it, because if I were to actually bring this to market, then immediately what's going to happen is that I'm going to get thrown into the PTAB.
People like me don't have a chance in today's world, in the patent system today. You don't have a chance. It all depends on whether the company that infringes on you is hostile or is your friend. It's all on them.
So we had to raise and expend $75,000 every week. I had to hire 6 different law firms, 3 different technical experts, 29 different attorneys, and the filings, you could fill a room with the papers that were filed. And so they just realized, we just bury this guy in litigation, he's gonna suffocate, and then if you fall behind on your bills, you lose. And so that's the trick. They know that we don't have those resources. And so these cases now, and patent cases, take 10 to 15 years to work through the courts. And I remember calling my wife after we got the order. I said, we won, we beat these guys have been in over 100 IP litigations, just like the Silicon Valley tech giants, and they had never lost. And so I'm like, we won, we beat them. And I had no idea. We hadn't even gotten to first base yet. 3 weeks later, they made a minor alteration to their product, and they filed their appeal, and the whole thing started over again.
I'm pretty much over. My patents were killed in 2015. I only have about 2 years left of enforcement if I could get another patent. And so, I'm pretty well done. But what the deal is, this is important. There's a lot of small individuals like me, that would never see any benefit of all their hard work. It's a whole different world. I always said that Thomas Edison would have never got a patent on the light bulb.
So his patent would have been invalidated, you think?
Sure. There ain't no way that they would have survived. I just, I don't believe our system was built on this manner.
We're trying to bring back the robust patent structure that really has helped America thrive with innovation. I look at the United States Constitution. The word secure is only in there twice. The first time is in the preamble, where it says, to secure the blessings of liberty for ourselves and our posterity. The second time, and the only other time, the word secure is in the Constitution, is to secure exclusive rights for authors and inventors to their respective writings and discoveries. So when I really look at Congress, in the enumerated rights or responsibilities of Congress, the word secure is used once. And that is secure exclusive rights for authors and inventors. And my message would be, help us help Congress do exactly that, to secure those rights.
Our country needs a patent system. That patent system needs to be predictable. That patent system needs to serve our nation. Without innovation, our country would not be where it is today. Innovation today has been stifled. Investment has been stifled. Extremely difficult. You're an upstart, you're a startup company, you have new technologies. The moment you enter the marketplace is the moment that you've given away that technology. And today, if you have a patent, you can rest assured there's a very small chance your patent is going to be withheld by the very office, the US Patent Office, who granted that patent to you.
Current common sense is almost like patents are useless. So we would like to see someone taking some action to strengthen the protection for US inventors. And after all, that is the core strength of this country. The ingenuity and the inventor's hard work really goes into the economy. It generates jobs, and it really encourages everybody who respect IP rights to go invent your own technology. Make your technology better than ours. Then we go into a fair competition as opposed to copy and then say you don't have a patent. How about respect the patent and let's compete together.
Today is an accounting. So in 9 years, the PTAB under the American Inventors Act has just been completely lopsided in favor of these huge corporations. Turns out Congress had a safeguard for this. They said the director shall prescribe regulations. The director shall consider the effect on the economy and the integrity of the patent system. And I read that law and I said, they didn't do any of that. That's why we're crashing so hard. They're taking all of our patents and subjecting them to this review with a predetermined outcome. And so we came to ask a judge, a federal judge, to require that they follow the law. And we believe if they do what they were told to do in 2011, that inventors and entrepreneurs will have a chance and be able to participate and compete with their better ideas. Because right now you can't.